Welcome back, America. It's Hugh on a very important day in the history of the Constitution and constitutional law. In a matter of hours, litigants will take their place before the United States Supreme Court in the case of Dobbs, and they will be arguing whether or not Roe v. Wade and Casey versus Planned Parenthood ought to be overturned. I'm joined by Princeton professor Robbie George, the McCormick Professor of Jurisprudence at Princeton, and Dr. Ryan Anderson, head of the Ethics and Public Policy Center in Washington, D.C. Both are expert on the issues of abortion and the Constitution. Welcome, gentlemen. I'd like to ask you both at the beginning, if you were the first to speak on behalf of the state of Mississippi, and you had your first 30 seconds to a minute to open the argument. Professor George, welcome. How would you begin your argument?
I would begin the argument, Hugh, thanks for having me on the show. I would begin the argument by pointing out that nothing in the text or structure or logic or historical understanding supports the idea of a constitutional right to abortion. The right, rather, was simply manufactured out of whole cloth by the Supreme Court in 1973. It was a grievous mistake, an abuse of constitutional authority, a usurpation by the judiciary of the authority vested by the Constitution and the people and their elected representatives, a stain on the conscience of the court, and should therefore be reversed.
Ryan Anderson, how would you begin your argument?
I would say everything Robbie just said, and then I would say that this wasn't just about some insignificant matter of law or legal doctrine. The consequence of the court getting this constitutional question wrong 49 years ago has been a violation of basic justice and human rights. Millions of Americans have been unjustly killed as a result of this unconstitutional decision from the Supreme Court. And so any of the stare decisis concerns need to be, significantly outweighed by basic considerations of justice here. They got the case wrong in Roe. They got it wrong again in Casey. And as a result, we've had a huge injustice, a huge violation of human rights. Lives have been lost, and it's incumbent upon them to get it right now.
I would begin by arguing
that... by stare decisis concerns, Ryan means the theory of precedent, the idea that even if a case was wrongly decided, it has precedential force and therefore should only be overturned or reversed for very good reasons. And Ryan was pointing out some of the very good reasons why the doctrine of stare decisis should not stay the hand of the court here in getting the Constitution right and overturning Roe versus Wade.
I would begin with that, actually, Professor George. I would begin by saying stare decisis should not stay your hand. You took a wrong turn 50 years ago. You're deep in the wilderness, carving new roads out, distorting constitutional law every day because of a mistake. And I would cite the Chief Justice's concurrence in Citizens United. How do you, Ryan Anderson, get around the stare decisis argument that this has been law for 50 years in the United States?
Well, I think you point exactly to that Citizens United concurrence. Right there, the Chief Justice laid out, a series of arguments about the difference between judicial restraint and judicial abdication. That's a direct quote from him. And he says, look, this isn't something that we can now be relied on because this hasn't been accepted by the American people. There's no issue in American constitutional law less settled than the question of abortion. There's a reason why hundreds of thousands of people come to the nation's capital every January in the freezing cold and march for life because we know that the court got this wrong. And so the idea that we're going to, in order to uphold uniformity of the law or an expectation of stability of the law, we're going to uphold a wrongly decided case that has never been accepted by the American people, strikes me as a false application of stare decisis, a false deference to precedent.
Professor George,
your listeners need to understand that there's nothing unusual about the court reversing itself. It's happened more than 200 times in the history of the United States Supreme Court, and sometimes cases of very long standing have been reversed. A good example is Plessy against Ferguson, the notorious ignominious case in which the court entirely wrongly upheld racial discrimination, despite the Equal Protection Clause of the 14th Amendment. But that decision took 60 years to reverse. So there's nothing novel or radical about reversing a bad decision, even after decades.
So let me stay with you for a moment, Professor George. You've been teaching con law longer than I have, but I teach law students who have to pass a bar. You teach undergraduates for whom getting it right is actually more important than knowing the law. What will be the reaction among your undergrads if Roe and Casey are overturned? Will there be rebellion? Will there be revolution? Because the proponents of Roe and Casey are predicting doom if they are overturned.
No, that's not going to happen. Obviously, the decision will be controversial, as the original decision in Roe against Wade was controversial. It will be more unpopular in some parts of the nation, less unpopular in others. In some places, it will be popular. The nation is divided. Young people are divided over the question of abortion and the sanctity of human life, the rights of the child in the womb. So this is not anything that we should be concerned about there being violence in the streets or revolution. That's not going to happen.
Ryan Anderson, if you were standing there, Justice Sotomayor, Justice Breyer, or Justice Kagan would say, what about those women who rely and have been known to rely upon the law that allows for abortion providers to provide that service? Will they not be definitely injured by the fact that they have relied on the availability of abortion but no longer can?
I think my response there is that we have failed those women as a political community. If you need to rely on abortion in order to flourish in our community, that's a sign that we have failed you, that we have not created a hospitable political environment, social environment, cultural environment in which both women and their babies can flourish. And so this is a huge opportunity. I think overruling Roe, overruling Casey is just the beginning of the pro-life movement to then enact public policies and cultural programs that will support both women facing unplanned pregnancies and the children, both of whom matter. Right? And so I actually think this is a huge opportunity for the pro-life movement to do what it's always been doing. Right? The media never covers the crisis pregnancy centers, the various support networks that already exist. This is a chance for pro-lifers to really highlight all of that work. And that would be my response, to say that, look, abortion is a failure for women. It's not something they should be relying on.
Professor George, is there a better response possibly in saying that if you issue a shape-shifting of the constitutional law decision, it would not be extraordinary for you to delay its effectiveness by 3 to 6 months?
Oh, I mean, of course, it's within the court's authority to do that, but I don't think the court will do that, and I don't think that the court should do that. Remember, when Roe versus Wade is reversed, as I very much hope it will be and trust it will be, when it's reversed, that will not mean that abortion is suddenly illegal. It will mean that the question of abortion is back to where it historically was before Roe versus Wade. That is in the hands of the legislatures, especially the state legislatures. And some legislatures, I think, will move quickly to restrict or prohibit elective abortions, that is, abortions where there's no threat to the life or health of the mother. And other states, New York, out there in California where you are, Massachusetts, the other New England states, will basically retain the regime of Roe versus Wade, but now not under constitutional mandate, rather by legislative action.
Professor George, I'm actually in the Beltway now, but the response that my friend Ruth Marcus would make is that there are on the books in many states springing statutes that will spring into operation if Roe and Casey are reversed, that will immediately, upon the reversal, spring into existence, barring abortion immediately. That is actually a good argument about people who have relied upon laws that exist. To what do you say to those statutes if Justice Kagan comes up with a specific statutory reference?
Well, I mean, if they're springing statutes and the laws come into existence, the laws come into existence. They come into existence precisely because Roe versus Wade was wrongly decided, and the court decides to return the issue to the legislatures. That means that legislation that's on the books will now be validly enforced.
Ryan, would that be your response?
Yeah, I mean, I think what we're going to see is about, I forget the exact number, I think it's about 15 states that have those types of trigger laws, that if Roe's overturned, pro-life laws go into effect. There are about 15 other states that have pro-choice laws that will be in effect. And then we're going to see about 20 laws where we're going to need legislation, and they're going to be political battles. And I just think that's, unfortunately, that's the way it has to be. My preference here would actually be that in the long run, we recognize that the unborn are persons under the 14th Amendment. But I don't think that's going to happen in this case. And so
that's not before the court.
of laws.
Right, that's not before the court.
Not in this case. No, they didn't ask that question. But I do think eventually what justice requires is that we protect unborn children in all 50 states. And so this will be a first step, but that's where we need to get to.
After the break, I'm going to ask you for your predictions about the outcome on the merits. But Professor George, how quickly do you think the court will move, not should move, but will move to a decision in Dobbs?
I think it's likely that it will not be handed down until well into the spring, perhaps even as late as mid to late June. Of course, there's nothing that requires the court to wait that long. It could hand down a decision as early as February or March, but I'd be surprised if that happened. I'm expecting it in June.
Ryan, we're about to go to the break, but I'd like your answer on that expectation on timing, and then what you think is the best argument from the opponents of reversing Roe and Casey.
I think the timing, this is likely going to be handed down on the last day of the term. Right? So we're looking the very last week of June would be my guess. I think the pro-choice side of this, all they can say is stare decisis and reliance interest, because no one seriously supports the idea that Roe got the constitutional law correct. And so at this point, all they can point to is precedent and reliance, and then use threats that if you overturn Roe, there'll be a civil war, there'll be rioting. And as Robbie already mentioned, I think those are empty threats. We're not going to see that sort of unrest from this.
That is, in fact, the triple crown of their arguments. Reliance and harm to people who have relied upon it. The fact that stare decisis and the threat to the court. We'll come back after the break and talk about the good that would come from a rapid, and I believe actually we might get a fairly rapid decision, not last day of court decision, when I come back. Don't go anywhere, America. Professor Robbie George is the McCormick Professor of Jurisprudence at Princeton, one of the preeminent public intellectuals in America, as is Ryan Anderson. Dr. Ryan Anderson is the president of the Ethics and Public Policy Center, and he is based in Washington, as Professor George is based in Princeton. They're going to be right back. Welcome back, America. I'm Hugh Hewitt. I'm joined by Professor Robert George of Princeton, Dr. Ryan Anderson of the Ethics and Public Policy Center in Washington, D.C. Gentlemen, I know for a fact that at least 2 of the 9 listen to this show every day. And sometimes they miss. I can say almost every day. What would you say to them about the outcome on the conservative cause for the court? The crisis that I think will occur if on this second setup, as Casey was the setup, that Roe be reversed, the court fails to do so. Professor George.
Well, if the court fails to do so, I think it means the continuing corruption of our constitutional law. It will cast doubt on the efforts now more than 50 years going of conservatives and especially constitutionalists really across the board to bring the courts back into line with constitutional principle. It will mean the conservative movement failed in its effort to restore true constitutionalism to our courts. I think the loss of faith in the judiciary by people across the spectrum will be profound. There will be a terrible price to pay if the court once again fails to do justice to the Constitution to uphold the rule of law.
Dr. Anderson, if they fail in their job again, they being collectively the court, will conservatives bother to defend it against the attacks from the left that would pack it and otherwise distort it?
I think if they fail to overturn Roe, I think we're likely to see a civil war on the right. Metaphorical, of course, but I mean, I think you're likely to see a further fissure of those who have been frustrated with the conservative legal movement, those who have been accusing FedSoc of not caring enough about social issues. I think if the court fails to overturn Roe, we're going to see a huge split on the right, and I think that would be tragic, right? I mean, I want Roe overturned because I think it's the right constitutional decision. I want Roe overturned because I think it will do justice to the unborn. It will allow us to protect them. But I also think it will be good for the right. I think otherwise we're going to see a splittering on the right that isn't going to lead to our long-term flourishing as a political movement.
I also believe no one will ever believe another judicial nominee again. Let me close by talking about the good that comes from the reversal of Roe and Casey, and I'll start with you, Ryan Anderson. What is the essential good? I see 2, but what do you see from the court having the courage to change what is obviously wrong and corrosive?
So I'll mention 3 real quickly. The first is that it will allow citizens and our elected representatives to pass laws to protect unborn babies. To my mind, that is the first positive outcome of a decision overturning Roe. Second is that it would actually get the Constitution right. It would get constitutional law right. It would restore credibility to the court by acknowledging that it made a mistake and it had the courage to correct its mistake. It would actually respect constitutional self-government. And then lastly, I think it would actually improve our judicial politics. I think confirmation hearings in the future would not be nearly as contested. Every one of the justices who's likely to cast a vote to overturn Roe went through hell during their confirmation hearings because the left was suspicious that they would be against Roe v. Wade. If we can finally clear the air of this and no longer have to mouth platitudes about Roe being good law, et cetera, we can actually have a healthier nomination confirmation process. So I see all three of those things as wins if the court does the right thing on this.
Professor Robbie George, what would you add to that or emphasize of that?
I would say that above all, a correct decision overturning Roe versus Wade would restore the integrity of our constitutional law. Whether you are pro-life, as the three of us on this call are, or pro-choice, you should understand that the Supreme Court disgraced itself by reading into the Constitution something that wasn't there, a right to abortion that's nowhere to be found in the text or logic or structure or historical understanding of the document. It was a pure imposition by the court and a usurpation by the court of the legislative authority of the people, the right of the people to make laws under the Constitution. That's got to be set right. Again, whether you're pro-choice or pro-life, you should understand that that's got to be set right. When Roe was handed down, even pro-choice constitutional scholars like the late John Hart Ely, then a professor at Harvard, later a dean of Stanford Law School, said that Roe versus Wade not only isn't law, it doesn't even show any effort to try to be constitutional law. He was right about that, and he was right despite himself being personally pro-choice and preferring as a matter of public policy the kind of regime of abortion law that Roe put into place. That's a reminder to us that at the constitutional level, what's most fundamentally wrong with Roe is that it usurps the authority of the legislative process, of the elected representatives of the people, and steals it and puts it in the hands of judges. And that's just constitutional corruption.
Succinct summary, gentlemen. I believe it will be a 6-3 decision overturning Roe. And Casey, what do you think, Professor George?
6-3.
Ryan Anderson?
We have a unanimous ruling on this one. I think it's going to be 6-3.
God bless you both. And thank you. You two have been working in these vineyards for decades. And it's important, it's grace-filled, and I appreciate the steady resolve and the cultural courage it took to stand tall, as both of you have, over so long on behalf of the unborn. And so people understand, on behalf of the Constitution as it ought to be understood, as it was written. Thank you, Professor Robert George, Dr. Ryan Anderson. I'll be back tomorrow, America, on the next Hugh Hewitt Show.